Civil Procedure Code Practice Questions Session 3. In this session, we will discuss the questions that may be asked in judicial services examination. We help the students in preparation of judicial services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. I am again repeating the number 8199898985. Question number 51. Which of the following suits is not of a civil nature? Option A, suits relating to right to property is a suits of civil nature. Option B, suits relating to right to worship, to share in offerings is also a suits of a civil nature. Option C, suits relating to taking out of religious procession is also a suits of civil nature. Option D, suits for recovery of voluntary payments or offering. Suits for recovery of voluntary payments or offering is not of a suits of civil nature. So answer is option D. Suits for recovery of voluntary payments or offerings is not of a civil nature. Question number 52. Which of the following suits is of a civil nature? Option A, suits for restitution of conjugal rights, dissolution of marriage is a suits of civil nature. Option B, suits for rent is also is of a civil nature. Option C, suits for rights of franchise is also of a civil nature. So answer is option D. D is answer. Question number 53. Which of the following suits is not of a civil nature? Option A. A suit to declare the election of a candidate as contrary to law, civil nature. Option B. A suit for right to bury a corpse is also a civil nature suit. Option C. A suit for right to services which are honorary and gratuitous is not of a civil nature. So answer is option C. Corpse means the physical remains of an expired human being prior to complete decomposition. Corpse means the physical remains of an expired human being prior to complete decomposition. Question number 54. Which of the following suits is not of a civil nature? Option A suit against deprivation from attending social functions. Is not of a civil nature. Option B, a suit for arrears of salary is a suit of civil nature. Option C, a suit for right of burial is also a civil nature suit. Option D, a suit for restitution of conjugal rights is also a suit of civil nature. So answer is option A. A is answer. Question number 55. A suit is said to be expressly barred. Option A, when it is barred by the provisions of the Civil Code. Option B, when it is barred by any enactment. for the time being in force. Option C, both A and B. Option D, only A. A suit is said to be expressly barred when it is barred by the provisions of the Civil Code, when it is barred by any enactment for the time being in force. So answer is option C. C is the answer. Question number 56. Which of the following sections of the Civil Procedure Code expressly prohibits a suit under certain circumstances? Answer is option B. B is the answer. Question number 57. A suit is said to be impliedly barred. Option A, when it is barred by general principles of law. Option B, when it is barred on the grounds of public policy. Option C, both A and B. Option D, only A. A suit is said to be impliedly barred when it is barred by general principles of law, when it is barred on the grounds of public policy. So answer is option C. C is the answer. Question number 58. Which of the following suits is said to be impliedly barred, that is, a civil court would have no jurisdiction? Option A, suits relating to acts of state is said to be impliedly barred. A suit to recover costs incurred in a criminal court is said to be impliedly barred. A suit to recover damages for defamatory statements made by a party in the course of judicial proceedings is said to be impliedly barred. So answer is option D. D is the answer. Question number 59. Mark the correct statement. Option A, a presumption is to be made in favor of the existence of the jurisdiction of the courts rather than its exclusion. This statement is correct. Option B, the statutes ousting the jurisdiction of civil courts must be strictly construed. This is also correct statement. Option C, when an issue arises which is required to be decided or dealt with by a competent authority under a special act, the jurisdiction of the civil court to decide or deal with the same is not only ousted, but the latter is under a statutory obligation to refer the issue to the former. This is also correct statement. So answer is option D. D is the answer. Question number 60. Which of the following is a leading case on the exclusion of the jurisdiction of civil courts? Option A, Dhula Bhai versus State of MP. Option B, Gundaji versus Ramchandra. Option C, Noor Muhammad Khan versus Fakirappa. Option D, all of the above. Answer is all cases are a leading case on the exclusion of the jurisdiction of civil courts. Answer is option D. D is the answer. D is the answer. Question number 61. Which section of the code lays down rule of res subjudice? Section 10 lays down rule of res subjudice. Section 11 res judicata. Section 13 when foreign judgment not conclusive. When foreign judgment not conclusive. Section 15 courts in which suit to be instituted. Answer is option A. Section 10 lays down the rule of res subjudice. Question number 62. Rule of res subjudice implies. Option A, where the same subject matter is pending in a court of law for adjudication between the same parties, the other court is barred to entertain the case so long as the first suit goes on. Option B, where the same subject matter is pending in a court of law for adjudication between the different parties. the other court is barred to entertain the case so long as the first suit goes on. Option C, where different subject matter is pending in a court of law for adjudication between the same parties, other court is barred to entertain the case so long as the first suit goes on. Answer is option A. A is the answer. The rule of res subjudice implies where the same subject matter is pending in a court of law for adjudication between the same parties, the other court is barred to entertain the case so long as the first suit goes on. Section 10 declares that no court should proceed the trial of any suit in which the matter in issue is directly and substantially in issue. In a previously instituted suit between the same parties and the court before which the previously instituted suit and the court before which the previously instituted suit is pending is competent to grant the relief sought. Section 10 declares that no court should proceed the trial of any suit in which the matter in issue is directly and substantially in issue in a previously instituted suit between the same parties, and the court before which the previously instituted suit is pending is competent to grant the relief sought. This rule, the rule applies to the trial of a suit and not the institution thereof. The rule applies to the trial of a suit, not the institution. It also does not preclude a court from passing interim orders. Such as grant of injunction and stay, appointment of receiver, etc. It, however, applies to appeals and revisions. The rule applies to the trial of a suit, not the institution thereof. So it is clear that the rule applies to the trial of a suit, not the institution thereof. The rule of res subjudice also does not preclude a court from passing interim orders such as grant of injunction or stay or appointment of receiver, etc. It, however, applies to appeals and revisions. The object of rule contained in section 10 the object of rule contained in section 10 is to prevent courts of concurrent jurisdiction from simultaneously entertaining and adjudicating upon two parallel litigations. In respect of the same cause of action and the same subject matter. And the same relief. The object of rule contained in section 10 is to prevent courts of concurrent jurisdiction from simultaneously entertaining and adjudicating upon two parallel litigations in respect of the same cause of action, the same subject matter, and the same relief. The policy of law is to confine a plaintiff to one litigation. The policy of law is to confine a plaintiff to one litigation. Question number 63. Which of the following is not an essential condition for the applicability of the rule of res subjudice? Option A, the matter in issue in the subsequent suit must be directly and substantially in issue in the previous suit is an essential condition. Option B, both the suits must be between the same parties or their representatives is also an essential condition. Option C, such parties must be litigating under the same title in both the suits is also an essential condition. Option D, the subject matter and the cause of action should be the same in the both the suits. Is not an essential condition. So answer is option D. D is the answer. Question number 64. Section 10 of the code does not apply. Option A, when the previously instituted suit is pending in the same court in which the subsequent suit is brought. Section 10 apply. Option B, when the previously instituted suit is pending in any other court in India. Section 10 apply. Option C, when the previously instituted suit is pending in a foreign court. Section 10 does not apply. Section 10 does not apply. Option D, when the previously instituted suit is pending in any court beyond the limits of India established or continued by the central government. Section 10 apply. So answer is option C. C is the answer. Question number 65. Mark the incorrect statement. Option A, under section 10 of C.P.C, a suit is liable to be stayed. This is correct statement. Under section option B, under section 10 of C.P.C, a suit is liable to be dismissed or rejected. This is incorrect statement. Option C, under section 10 of C.P.C, the second suit is to be stayed. This is also correct statement. Option D, the provisions of section 10 are mandatory. This is also correct statement. So answer is option B. B is the answer. Question number 66. Mark the incorrect statement. Option A. The court in which the previous suit is instituted must have jurisdiction to grant the relief claimed in subsequent suit. In the subsequent suit. This is also correct statement. Option B, section 10 applies only to suits and not to applications and complaints. This is also correct statement. Option C, the term suit in section 10 does not include appeal. This is incorrect statement. Option D, section 10 can come into operation after settlement of issues in the subsequent suit. Also correct statement. So answer is option C. C is the answer. Question number 67. In which of the following cases section 10 will apply? Option A. When the earlier suit was for recovery of rent for certain period, the subsequent suit is for recovery of rent for subsequent years and for ejectment. In option A, section 10 does not apply. Option B, B is a merchant residing in Delhi. He has an agent A at Mumbai to sell his goods in Mumbai. A sues B in Mumbai claiming a balance due from an account in respect of dealings between A and B. While this suit is pending in Mumbai, B files a suit against A in Delhi for an account and for damages caused by A's alleged negligence. In this situation, section 10 apply. Option C, previous suit is for men's profit and subsequent suit is for title. In this situation also section 10 will not apply. So answer is option B. B is the answer. Question number 68. Which of the following remedies is available against a court's order under section 10? Option A, appeal. Option B, revision. Option C, both A and B. Option D, none of the above. Answer is option B. B is the answer. Question number 69. Doctrine of Res Judicata implies. Option A, a thing which has been decided. Option B, a bar to the trial of a subsequent suit on the same cause of action between the same parties. Option C, things once decided by the competent courts should be taken as conclusive truths until they are reversed by any higher court. Answer is option D. The doctrine of res judicata implies on a thing which has been decided. It is a bar to the trial of a subsequent suit on the same cause of action between the same parties. Things once decided by competent court should be taken as conclusive truths until they are reversed by any higher court. So answer is option D. Question number 70. The doctrine of res judicata is based on option A, public policy, option B, private justice, option C, both A and B, option D, none of the above. Answer is option C. C is the answer. Question number 71. Which maxim is applicable in relation to the doctrine of res judicata? Option A, interest republicae ut sit finis litium. It is to the interest of the state that there should be an end to litigation. Option B, nemo debet lis vexari pro una et idem caesua. That is, no one shall be vexed twice over same cause of action. Option C, both A and B. Option D, none of the above. Both these maxims, interest republicae ut sit finis litium and nemo debet lis vexari pro una et idem caesua, is applicable in relation to the doctrine of res judicata. So answer is option C. C is the answer. Question number 72. In which of the following cases it was laid down that there are two purposes behind the rule of res judicata? First is end of litigation. Second is protection of individual from multiplication of litigation. Option A, Ghulam Abbas versus State of UP. Option B, Manohar Lal versus Seth Hira Lal. Option C, Shetty versus Girdhar. Option D, none of the above. Answer is option A. In Ghulam Abbas versus State of UP, it was laid down that there are two purposes behind the rule of res judicata. First purpose, end of litigation, and second purpose, protection of individual from multiplication of litigation. Question number 73. Mark the incorrect statement. We have to mark incorrect statement. Rule of res judicata is basically technical. This is incorrect statement. The principle of res judicata is founded on justice, equity, and good conscience. This is correct statement. Option C. The principle of res judicata is a part of rule of law. This is also correct statement. Option D. Rule of res judicata would apply to all judicial and quasi-judicial proceedings, whether civil or otherwise. This is also correct statement. So answer is option A. A is the answer. Question number 74. Who said, in relation to the doctrine of res judicata, the right of an individual is to be protected from multiplication of suits and prosecution at the instance of an opponent whose superior resources and power at the instance of an opponent whose superior resources and power, unless curbed, may render futile judicially declared right and innocence. Option A, Lord Denning. Option B, Lloyd. Option C, Spencer Bower. Option D, Dice. Answer is option C. C is the answer. Question number 75. Which of the following is an essential element of rule of res judicata laid down in section 11? Option A, the former judgment must be that of a court of competent jurisdiction. It is an essential element. Option B, the former judgment must be directly speaking upon the matter in question in the subsequent suit. It is also an essential element. Option C, the former judgment must be between the same parties. It is also an essential element. Option D, all of above. So answer is option D. D is the answer. We help the students in preparation of judicial services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. 8199898985. My email ID is legalbuddy@gmail.com. gmail.com. Thank you.